Today we're going to be looking at the Mental Health Use of Force Act, which is also known as Cheney's Law. And we've got three incredible speakers, so really, really fortunate. We're going to hear from Emma first, who works over at Erin Mitchell, and Emma's going to talk to us about what the law says. Then we're going to hear from Guy Cross at CQC, and Guy's going to talk to us about CQC's work in addressing use of force, and also touch about how advocates can get involved in the law. Emma, shall we hand over to you now? And you're going to talk us through the Mental Health Use of Force Act itself. Shall I begin with your slides? Okay, over to you.
Great, thank you. I will try to keep my eye on the chat. If I miss anything, I'll make sure to go through any questions at the end as well. So as Kate mentioned, my name is Emma. I'm a solicitor at Erin Mitchell in the Public Law and Human Rights Department. I was due to be joined by my colleague Sophie today as well, but she is unwell, so I will take you through a quick whistle-stop tour of the Mental Health Act use of force, which came into
is being recorded.
I don't know whether that was just me that tapped out there.
I think so. We've got you back. So.
Okay, brilliant. Hopefully that will be the only time that happens. So as I was saying, the Act came into force on the 31st of March of this year. And there's also some statutory guidance in place that was published earlier on the 7th of December 2021. So I'll go through kind of the main points from both of those. So as we've just seen on the very moving video from Cheney's mother, the background of this act is what happened to Cheney, and the idea is to prevent similar situations so that this doesn't happen again. The aims reflect this, so you'll see there up on the screen that it's the idea of this act is to end the disproportionate use of force on people sharing protected characteristics, particularly race, sex, age, and disability. There's a move to try to prevent the escalation of these situations, and also for there to be a refocus on the impact that it has on patients, taking into account a greater understanding of the histories of trauma and abuse that people have suffered, often people's backgrounds before being admitted into mental health hospitals is also very traumatic, and so the impact of force is likely to be even greater against that backdrop. There's also an emphasis on involving patients and their families and carers in the delivery of care. This is something that, as your role as advocates, you can be involved in. And there's an aim to create positive relationships between those receiving care and providing it. It's obviously very constructive to patients' treatment, which is the purpose that they're there for, to have good relationships, and the use of force can often break that down. Next slide, please, Kate. So the Act sets out a number of definitions. I've put three there. So the first is mental disorder, which you may be familiar with. That definition is it's the same as in the Mental Health Act 1983. So any disorder, and there's a list in the Mental Health Act Code of Practice of various disorders or disability of the mind, including where a learning disability is associated with abnormally aggressive or seriously irresponsible conduct. You may be aware that there's some reforms coming into force of the Mental Health Act, so there may be some changes to this definition, in particular in relation to learning disabilities, so we'll have to keep an eye out for that. Mental health unit, so this includes hospitals where treatment is being provided to inpatients for a mental disorder, and independent hospitals where at least some of the treatment is for the purposes of the NHS. It doesn't include any Section 135 or Section 136 suites or outside of a mental health unit, outpatient clinics or transport vehicles, which is probably a bit of a shame, really. But it is slightly limited there. At least it does include those places that may be a private hospital but carry out some acts for the NHS. The use of force, again, this is a similar definition to what you may be familiar with. So that will include the use of physical force, so that would be contact, mechanical, so the use of a device, for example, as Denny's mother was describing, or chemical restraint. So that would be the use of medication. Isolation of a patient refers to seclusion or segregation. So where the patient may be put in a room on their own, and there's also certain regulations in terms of making sure that there are checks on the patient, which is separately under the Mental Health Act. Next slide, please. So one of the key things that this piece of legislation brings into effect is the appointment of a responsible person appointed for each relevant organisation. They have a lot of responsibilities, so they must have the appropriate skill and experience needed to be able to implement these requirements. First one of which is to publish a policy regarding the use of force by staff who work in units and setting out the steps to reduce the use of force by staff members. So that's under Section 3. Section 4, they have a responsibility to publish information for patients about their rights in relation to the use of force, and to take reasonably practical steps to ensure that patients are aware of information and understand it. So as part of preparing these, it's important that they consult with relevant persons and publish policies. So these are both seen under the Section 3 and Section 4 for the respective policies. And they must keep these under review. So just because a patient wasn't around initially before the policy was being put out, they should still be able to be involved going forward. So if you have clients that have concerns about what the policies are, then you can support them to address any concerns they have. And it's also obviously important that you ensure that patients do have this policy about the information about their rights. And I'll go on to explain further what these are. The policies are also to make sure that they are relevant to the particular client group. So they shouldn't just be a policy across all hospitals, but they should reflect the patient group and be culturally appropriate and respectful, responsive to cultural differences, beliefs, practices of the patient population. As Shani's mum was saying, there's different responses, and it's important to reflect the culture of the different patients that are within the hospital. Next slide, please. So as I said, looking slightly further at what the policy to reduce the use of force should include, the statutory guidance in terms of accountability there's an emphasis on kind of ensuring protection of human rights, but the two that I wanted to focus on here are the bottom two of that list as they relate to your roles as advocates. So this policy must include how patients, their families, carers and independent advocates will be involved in care planning that sets out preventative strategies to use force. And then also that final point there, that you can also be involved in raising concerns about how force is used, and in terms of the post-incident review and follow-up, making sure that there is reflection on how if the use of force has impacted physically and emotionally on the patient and in any follow-up care they have. And then just having a look a bit further from the statutory guidance in terms of what the information regarding patients' rights should include. And this is reflected in the Mental Health Act as well, there should be a clear statement that the use of force is only ever used proportionately and as a last resort, and that it can never be used to cause pain, suffering, humiliation, or as a punishment. Now, you may have spoken to clients who have had force used against them, and they may disagree that that is how force is used, and the whole emphasis of this act is to stop that from happening, so that it is only used in these circumstances. The information should also include what type of force would be used, and that should help patients be able to make decisions and kind of act accordingly. And there should be details about their involvement in care planning and reviews, and also for them to recognise and understand that if force is used inappropriately, action will be taken and what that means, and that they have a legal right to an independent advocate, and also information about the complaints procedures they may want to use this if they think there's been force used inappropriately. So there's more points in the statutory guidance as well. I also wanted to highlight that when patients are admitted to the ward, they should be given this information as soon as reasonably practicable. Now, sometimes, obviously, when the patient is initially being admitted, they may not want to be given all of this information. There's a lot of information to take into place in a new environment and a very stressful situation. So if they refuse to take the information initially, this doesn't let staff members off the hook. They still need to make further attempts at reasonable intervals to provide the information in an appropriate format. And there may be some reliance here on independent advocates to assist in making sure that patients understand those rights, particularly where there may be a lack of trust in staff, which may make receiving the information from them difficult. Another interesting thing that I think is quite good from the statutory guidance is that it notes that it would be good practice to offer other persons who may have witnessed the use of force the opportunity to debrief with a staff member who was not involved in that use of force. So this act isn't entirely limited to people where there is use of force, but also others who experience it secondhand, because that can, of course, have an impact on everyone on the ward. Next slide, please. So again, in the video, one of the things that was discussed is potentially the lack of appropriate training where people are using force and how that can result in negative outcomes. So Section 5 of the Act requires that the responsible person must provide training for the staff that relates to the use of force by staff who work on that unit. So there's a variety of different things set out here. You'll see the top points emphasise involving patients and how staff members should be doing that. There's also focus here on understanding the impact on patients. So that should be kind of taken into account and making sure that there's that focus there again on the patients themselves. You'll see sections 5C and D there. So it's to training in relation to showing respect for diversity generally and avoiding unlawful discrimination, harassment and victimisation. So in the consultation kind of lead up to this act, there was consideration of data from the NHS Digital Mental Health Bulletin, which showed disproportionate use of force against some groups who share protected characteristics under the Equality Act 2010, so such as people from Black and minority ethnic backgrounds, women and girls, and also people with autism and a learning disability. So there is, again, this focus here on equality and making sure that there is attention paid to that. Refresher training is meant to be provided at regular intervals, and there's also more information in the statutory guidance about what should be involved in the training. One thing that might be quite helpful to do if you're concerned about the training that's being provided on a ward, you can always ask for when this training has happened, or maybe there's been an incident that's happened and you want to make sure that the staff members who are involved did have the necessary training. There's definitely no harm in asking. Next slide, please. So section 6 focuses on requirements for reporting. So 6.1 requires that the responsible person for each mental health unit must keep a record of any force used by staff who work on that unit in accordance with this section. I'll go on to explain a little bit more about what exactly doesn't necessarily need to be recorded, because there is a very minor exception. And section 6.5 sets out an extensive list of information to be recorded. So that will relate to numerous different details about the patient, the staff members that are involved or anyone else, the outcome, exactly what was the force used, what led to it, what was the outcome. So all of these things do need to be recorded, and so there should be quite a lot of detail in this. And it's noted in the guidance that success shouldn't be measured on a reduction in the number of reported incidents alone. You can kind of foresee staff members not wanting lots of reports because it may reflect badly on the unit, but it's emphasised that it is good practice to investigate and interrogate these incidents to produce a lessons learned report. So there's probably reassurance there to mental health wards that it's not a bad thing to have these reports. It's actually very important that it is, because use of force is such a serious thing to do, and it should be recorded. On to the next slide, please. So there we see what is considered to be negligible force. So it has to meet this criteria set out here. The first being that it must be the minimum force necessary to carry out therapeutic or caring activities. So, for example, personal care or reassurance. That it also must form part of the patient's care plan. So there's a bit of foresight there. There must be valid consent from the patient. So this is either directly from themselves if they have capacity to do so, or maybe where the patient is a child, their family or carer could provide consent. In order for it to be valid consent as well, you have to take into account principles of the Mental Capacity Act as to whether a person has capacity to be able to give that valid consent. If it's assessed reasonably that they don't have capacity to give that consent, then Section 5 provides the defence that you may be familiar with, that a person must reasonably believe that the person lacks capacity in relation to the matter, and that it will be in their best interest for the act to be done. And then only there's kind of a set of circumstances that it will be considered that it would never be negligible. So, for example, when mechanical restraint is used, or if the patient is resisting, then that's not going to be negligible. Even if there is regular use of negligible force, ultimately it is still force being used, and therefore if this is happening often, it may be helpful to request a restraint reduction plan, which would include details about the forces being used and any measures to reduce it. One example that's given of what negligible force could be would be the use of a flat hand, so not a grip, just guiding a patient, just one staff member guiding a patient to provide the minimum necessary redirection or support to prevent potential harm to the person. Before I go on to the next parts of the Act, I can see that a lot of comments have come through, and I can't see them both at the same time. So I'm going to quickly pause here.
While we're on mouse, Emma.
Yeah, that would be great. Thank you.
Okay. First one was, why does it not include A&E?
So that's a good question. It would be certain A&E suites, so where a patient is being sectioned under the Mental Health Act, so it's just not going to cover those section 135 or 136 suites. So when people are sectioned under those sections of the Mental Health Act, which can be used by the police, and it's more short term, so they will only be for not quite as long a period, and then once they were maybe put onto section 2 or section 3 of the Mental Health Act, it's likely that this would still apply.
Brilliant, thank you. Does it include CAMS?
Does that mean use of force by CAMS? If it does, then it's going to be anyone who is using force. Although, no, it wouldn't. But it is related to the wording is staff members. So things such as the training. Really, I wouldn't expect people from CAMS often using force. And where someone doesn't, in any event, where someone isn't trained to use force, they shouldn't be using it. Right, yeah. They should be calling for support.
And another one about settings. Does it include prison with people with identified mental illness?
It's not set out explicitly, but I would expect someone in prison to be, where this applies and where we're kind of thinking in a mental health context, to be transferred from the prison into a mental health unit on a prison transfer section. So the police and prison officers may rely on other kind of powers to be able to use force, and then they would have to apply those guidance.
That's great. And then there was quite a few questions about advocacy. So at the moment, informal patients don't have a legal statutory right to advocacy. And there's been quite a few comments and questions around, does this extend statutory right to informal patients who are subject to force?
So there's nothing in the Act itself that extends that. But where a patient has been subject to the use of force as part of the review process, it is noted that they do have that right to legal force, and they can also seek legal representation. And quite often, if we have patients who are voluntary patients and they would be coming to us, we could potentially suggest that they have an advocate as part of making sure that they are represented and we're able to communicate with them well.
Yes, so that's interesting, because that's probably what we class as pushing on the door for a lot of the statutory advocacy service. We're having that conversation perhaps with the hospital about making advocacy available. Yeah, lots about eligibility. How does the training work when lots of units use temporary staff? That was a good.
So this is difficult, and particularly because I know there is such difficulties within hospital settings to get the right staff in and to not have to rely on agency staff. But really, the responsible person should be taking responsibility for that, and it really should be even prior to this act coming into place. Staff should not be using force unless they have the right training to do so.
Great. Okay, and we'll just do one other quick question if that's all right, because I know we've got loads to do. Is it applicable to people held on doles?
So you would expect if they're within a hospital setting under doles, then yes. If it's a doles, for example, in a community setting, then this wouldn't necessarily apply because it's not a mental health unit.
So it's about the unit the person's on rather than the legal basis for them being there.
Yes, I'd say so.
To think about it. Great. Okay. Yeah, I think that'll. There's a few more, but I'll try and keep a hand on them. Do you want to carry on?
Yes, I think we're on slide 10. So you'll see the reason I kind of pause there, because we now it's a slight move away from your role as advocates, and there's a focus on in section 7 and 8 on responsibilities of the Secretary of State. So the Secretary of State must ensure that at the end of each year, statistics are published regarding the use of force by staff who work in mental health units. So that would include details of the use of force, protected characteristics of patients who the force has been used against, and whether or not they suffered serious injury or died. Section 8 requires that they publish a report having taken into account the published information and findings relating to death of patients as a result of use of force. So there should be that review and published information there. And then also moving on to section 9, this looks at when a patient dies or suffers a serious injury in the mental health unit, the responsible person for the mental health unit must have regard to any guidance. And there I set out what that guidance is. So this is already existing duties, but it's just emphasising here that the responsible person must have regard to those when there's an investigation of death or serious injuries on the unit. And just to note here from the statutory guidance that where there is serious injury or death of the patient, so in the case of serious injury, the patient themselves, or in the case of death or serious injury, their family or carers, should be communicated with in an open and honest and compassionate manner about the investigation and what's happened. And they should be kept informed at every stage and be able to be involved. And maybe that's where you could assist as well in that kind of review process and investigation. Moving on to section 10. So this focuses on responsibilities of the police. They should be wearing body cameras when attending a mental health unit. And this also goes to the accountability and helping understand what's going on, and hopefully a deterrent as well. So they should have the camera on them if reasonably practicable, and only in special circumstances would they not be required or expected to use that body camera. Although section 10.4 does include that failure by a police officer to comply with the requirements for a body camera does not in itself make an officer liable to criminal or civil proceedings, but it could be taken into account. So where we find, for example, that the camera, the recording's gone missing, or the batteries weren't working, or it was blocked or something like that. One of the unfortunately kind of things that I've heard before, it can still be taken into account, which is helpful. And I wouldn't expect it to be the police to be completely liable as a result of that, but at least it does kind of strengthen any arguments that we can make. Moving on to the kind of other guidance, so just a final point here to note that the statutory guidance for this Act doesn't override other guidance in place, notably the Mental Health Act 1983 Code of Practice, which you may be familiar with, Chapter 26.27 includes that where a person restricts a patient's movement or uses or threatens to use force, then that should be used for no longer than necessary to prevent harm to the person or others, be a proportionate response to that harm, and the least restrictive option, which I think we would all agree, having listened to Shani's mother speak, that was not applied in his case at all. And unfortunately, that is the case in other situations as well. But moving forward, there should be emphasis on ensuring that there is a reduction in that use of force as a result of this act and guidance. And then on final slide here, just to kind of quickly reflect on the application for IMHAs and advocates. I'll try not to step too much on the other speakers' toes on this as well. But I think generally the main points that we've touched upon going through these slides very quickly is that there is a role as a result of this act for advocates to ensure that patients are fully supported in relation to this need to reduce the use of force, and to ensure that patients continue to be at the centre of consultations and reviews and be able to inform the care that they are provided with. So they should be able to be part of their care planning and understand the kind of the nature of being in hospital and what is suggested, what use of force might be used and when. And then the recording of force also kind of goes to their rights in terms of that as well. So as I mentioned before, if there is a suggestion that there has been excessive use of force, then I would always suggest seeking legal advice, even if it's just a quick discussion with a lawyer that you're referring to see whether there may be some prospects of a claim there for a number of different reasons. And there are certain different kind of claims that could be made. So it may be that it's a repeated incident, the hospital were very familiar with it being a risk, and therefore you may have a negligence claim. It's quite hard to get a negligence claim, but if it's if it's clearly something that the trust was aware of, that might be possible. Alternatively, there's a 3-year limitation period to make a claim for an assault in civil law. And again, if a client is seriously injured on the mental health unit, you may be able to support them during the investigation process and any kind of post incident discussions. So, Kate, would you mind just running me through those questions again, because I've seen quite a few have come in.
Sure. So I think people are still getting stuck on the IMHA, or informal patients eligible for advocacy. So I think we just need to clarify that no, there's no extension to IMHA in England. In Wales there is for informal patients, but it makes sense for the managers particularly to be speaking to the commissioners and to be speaking to hospital managers about it. In my experience, when you ask the commissioner if it's okay to work with an informal patient, they don't say no. And if they do say no, then that's the bit to kind of then respond to, isn't it? So I wouldn't be really rigid in it. Maybe just have a chat. Right, so the questions are about timeframes, if that's okay, Emma. Is there a time frame for it to be implemented in mental health units?
It should be being implemented.
So it's now, isn't it?
Yeah, so yeah. I'd get asking those questions. It may be that they haven't published the policies yet, but those consultations should have started. And
is there a time frame for the policy? That was another question.
It's not set out in the Act whether, when these policies need to come into place. I'd have to have another look at the guidance, but from memory, I didn't see any kind of time specificity as to when they need to be published by.
And is there a time frame, last one on time frames, is there a time frame when every unit has to have a named responsible person?
Well, so I mean, the Act is in force. It came into force at the end of March, so I'd say that they should have that already. Yeah. Unfortunately, it may just be the case that it's delayed, but yeah, maybe they need a nudge.
Gentle nudge. Yeah. And then last question, and we'll then go to Guy. Any thoughts? There was a question around, can you clarify how force and then the issue of consent would be compatible?
So I think I take the point as to what that person's said, because really when you're going to want to consent to force, but I think the idea here is that when it's such minimal force, it's negligible force, the concept of someone just guiding you with a hand on your back, you may well consent to. You know, staff members saying, I'm just going to put my hand here, is that okay? And guiding someone over. But in terms of when a patient resists, that's never going to be negligible force. That's going to need a record.
Got you. Thanks, Emma. I'm conscious of time, so if it's okay, we will go over to Guy. Well, thank you for that. Are you able to stay around until the end if there are any kind of panel?
Yeah, absolutely. Yeah, I'll hang on.
Is that all right? Thanks, Emma. Right, welcome, Guy.
Thank you. Yeah. If you could just tell me when you're changing the slides, okay?
So we're good to go when you are.
Okay, great, thanks. So yeah, I'm Guy Cross. I'm a policy officer in the CQC. My particular area of interest is restrictive practice, not just in hospitals, but across all the settings we regulate. So I'm just going to talk to you today about how CQC has been involved so far, what our approach to the Act is, and then happy to take any questions. I just clarify something from one of the earlier questions. You asked about whether it applied in prisons. I think the AG's intention was that it would apply everywhere, but the only way that Steve Reid could get it through Parliament was to limit where it applied to start off with. So over time, the intent would be, certainly from the Lewis family, that it applied everywhere. So it applied in social care, in schools and in prisons as well, but it doesn't at the moment. Okay, so first off, CQC regulations. So clearly use of force isn't a new thing, and CQC's regulations already enable us to take action. And what I've done there is just put up some of the regulations where we have taken action around the use of force. So I guess none of them are surprising if you think about what could come under those categories. The training one in particular, I'll focus on for a little bit. There's a requirement in the Act that training should be certified as complying with the restraint reduction network training standard. CQC's had an expectation that happens since back in I think 2021. We had that expectation, but it wasn't a requirement because we don't have a regulation that says you must do that. But now the Use of Force Act and its guidance essentially say for hospital settings, you must do that. So that's sort of strengthened our hand, if you like, on that one. I think the others the other regulations there are quite straightforward. But if you've got any questions on how they apply later on, then I'm more than happy to talk to you about that. So just bear with me a minute. So the other bit of what CQC does and where advocates may be more used to interacting with CQC is around the Mental Health Act monitoring. So we regulate all services that require registration, but we also have a function to monitor the use of the Mental Health Act, and that's what the Mental Health Act reviewers do. So they go around to inpatient settings, they can go when they want without notice, and basically try and ensure that providers are doing what they're supposed to under the Mental Health Act. So what I've put there is just some of the things that they consider. So we've mentioned Chapter 26 already. There's a heck of a lot of detail in there about the use of force. I had a call yesterday with the Mental Health Act reviewers thinking, all right, so what's our role within this? How are we going to work with inspectors and others to make sure that the Use of Force Act is followed? And what questions should we be asking? Because again, just a quick recap, their role is specifically about the Mental Health Act, but there is a sort of overlap between the Mental Health Act and the Use of Force Act to some extent. So, sorry, we should be on CQC and seniors law. I didn't say please change the slides. Apologies for that, Kate. That's
Okay.
my mistake.
Right.
So it's CQCs and Shaney's law, which I think is slide 4.
Yeah, we're on that now.
Yeah, so a little bit about what CQC, what we've done so far. So we weren't very involved in the drafting of the Act. I think if we had been, we might have done that slightly differently, but we were involved in some of the elements of the statutory guidance that came out. So there was a discussion earlier about negligible force. We were very involved in trying to work out how that would work, so we weren't creating a massive loophole, but at the same time, things that wouldn't be considered as force were recorded as force. So hopefully we've got that balance about right. I think we have. So the Act itself doesn't mention CQC. The statutory guidance does, says we're a monitoring organisation for that, but it doesn't give us any powers to do that. So that's why I started off with the regulations. Anything, any action CQC takes would be taken because of a concern or a breach around the regulations that are listed above, and any other regulations that we have that could possibly apply. Again, I know that colleagues at the Department of Health initially looked at creating a new offence under this as part of this Act, but they decided against doing that. That's why we don't have any additional powers, and there's no specific offence of breaching any part of this Act. Okay, next slide, please. Okay. So there were some questions there about when the Act comes into force and when we should be expecting people to have everything in place. This is clearly the Act came into force on the 31st of March, but CQC's approach at the moment is to work with providers and to not give them more time, or fixed amount more time to get everything in place, but to ensure that they are aware of what the Act says and that they're working towards doing it. So yeah, it's a slightly difficult position to be in, but CQC did the same with the Code of Practice when that changed back in 2015. I was working at the Department of Health at the time and have been involved in chapter 26 and a couple of other chapters of the code, and there was some time basically for trusts to adjust their, well, for providers to adjust their approach. But that said, if there's something that's blatantly wrong and they're not aware of the requirements of the Act, then we would be considering what action we would take there. So we focused, I suppose, on two areas really so far. It's in upskilling our inspectors. So you're probably aware we've got a series of brief guides about all sorts of things. There's a brief guide on the Use of Force Act. We've also done some training and some awareness raising for inspectors. So again, they're familiar with what the Act says and what we should expect of providers. I think what it does do is, despite it not giving us any new powers, it strengthens our hand to an extent. So the Code of Practice, you may be aware, already says that there should be a policy about use of force. It doesn't put it exactly in those terms, but there is a requirement for that. Whereas the statutory guidance here says, and this is what it should include. And it goes further than that. It says, and this is how, who you need to consult on that policy, and this is how you should best co-produce that policy. And again, it says you should be reviewing that policy as well. So it's not something you do this year and then never come back to. The idea is that based on experience and any change in demographics, for example, any changes in practice, so what may have been reasonable may be shown to be unreasonable going forward from a court case. So they need to take account of that and to work there. So it really strengthens our hand in deciding whether people are acting appropriately or not. They can't just say, yes, we've got a policy, we've ticked that box. The policy needs to be a proper attempt to reduce the use of force, set out what force we can use, how we're going to reduce it, how that differs by different so we've been doing some work with providers so far, basically making sure that they're aware of the requirements of the Act. It's a shame to some extent that it went through 2018, but was only commenced in March 2022. But on the other hand, there's some benefits there, because in that time, there's been a lot of change to both the mental health services data set. So that's got the level of detail that's required in the Act. That was done in that time frame. And also the Restraint Reduction Network training standards came into force at that time as well. So the things that were required under the Act have already been taken care of, whereas in other circumstances that isn't always the case. So next slide, please, Kate. And this is just what we're going to be doing going forward. So our expectation of providers is that they are, at the very least, aware of the Act and working on implementing it if they haven't done so already. Good providers, we know some of them have been working as if the Act was in place for quite some time. In some of them, it is over a year they've been doing that. They started looking at it as soon as it was enacted back in 2018. We are going to be using some blogs from our Deputy Chief Inspector, the person responsible for mental health in hospitals within CQC, basically reflecting on what our inspectors find, but also I think giving some support to providers to say, this is what we want you to be doing, this is why it's important. So the first one we're going to do, which I'm in the midst of writing at the moment, the Deputy Chief Inspector, is around the requirements around data, what flows from that. So just going back a little bit, there's the policy that should be reviewed. There's no point in reviewing your policy if you don't think about what you've done in the interim period. So one of the things we would expect is that providers would have a look at their data and say, all right, what have we done? Have we used force that we shouldn't have done, as in any techniques? The point about agency staff, do we need to do something more around agency staff and their training? And then ultimately there's enforcement. So I mentioned earlier that any action we take would be under the regulations that CQC already has. And so any breach of this Act, we need to put under one of those regulations, but we will be using it, full scope of our enforcement powers to make sure that providers do what they're supposed to under this Act. Hopefully it's another step in reducing the use of force in all services, not just in hospitals. It's a starting point in hospitals, but I think the way we approach this and the action we take will also have will also influence other services. I think that's it from me, Kate. I just wanted to outline what our involvement's been and what our approach has been so far and what we're intending to do in the future. But I'm more than happy to answer any questions either now or later.
Okay, sorry, I think you're on mute.
Oh, that was a silly mistake, wasn't it? You'd think I'd know better. Thanks, Emma. So yeah, Guy, there were just two quick questions, if that's okay. One was about, are PICU hospitals permitted a greater level of discretion in interpreting and applying this act because they've got higher risk patients in their care?
No, I wouldn't say a higher level of discretion. So if you think back to the policy that the provider has, the provider's policy is supposed to cover all of the inpatient units that they have. But that doesn't mean it's the same policy on each of those units. So there may be something specific about PICU and what force they would use within that unit. So no, is the simple answer. There isn't any greater discretion, but the provider's policy could set out that they do something different within that service.
Yeah, and things like proportionality and that least,
Indeed,
the least force that necessary, isn't it? Yeah, to be thinking about. Have you any thoughts, Guy, around connections and best practice with advocates? Because I think it's something that the advocacy community often thinks about, is our relationship with CQC in that kind of intelligence, you know, raising concerns and sharing intelligence about a hospital. Any thoughts on what you'd like to see from advocates with the use of, not use of force, but trying to reduce the use of force?
Yeah, I don't think it's changed because of the introduction of this act, but I don't think it's changed because of this act to the extent that if there were any concerns beforehand, then we would hope that you would have raised them anyway. But what this act does is it sets out in more detail what providers should be doing. So if you have, when you're working with patients, you come across something that doesn't sound right in terms of your understanding of the act, then let us know in the same way that you would have let us know about any concerns you had prior to the act coming into force. The act I think mentions advocacy a couple of times within it. So I suppose if things are happening and you're not involved in the way that you would expect to be involved, then that would be something to tell us. That would be the new thing. But other than that, if you're concerned about the use of force, then I hope that you would have been in touch with us prior to this act coming into force. After this act has come into force, so now there's something more specific that you can reflect on and say for yourselves, well, to my mind, what they've done to this person isn't in line with the policy that they've got, or this person hasn't received the information about use of force that they should have done. I think those are the two most likely areas where advocates may have a concern that they wouldn't have done previously.
Got you. Thanks, Guy.